Your Honor, it is one thing to lose a close friend. It is another. Your Honor, you can hear me? There is some disturbance on your end. It is one thing to lose a close friend.
Sorry about that.
It is another thing to lose a close friend in your company, but it's devastating to be arrested for the death of your close friend. That's what's happening to the respondent in this case. Your Honor, she was arrested at the Nairobi hospital on Friday. That's Friday last week at around 9 p.m. Your Honor, the reason he was arrested at the hospital is that after the deceased doctor collapsed in her house,
Yes.
she called
Yes.
a neighbor, who in turn called an ambulance. And Your Honor, she immediately called the doctor for the deceased doctor, who is known to be under medication and suffering from pre-existing conditions. And it is the doctor,
She immediately called.
the doctor, a personal
Yes.
doctor of Dr Obwaka. Your Honor,
Yes.
I'm referring to a doctor called Dr Munyeri, who actually asked her to ensure the ambulance takes the deceased doctor directly to the Nairobi hospital. That was her first reaction when the doctor collapsed in her house. Your Honor, to start responding to the application by the DCI, which you oppose vehemently and find no merit in it, Your Honor, the application has paucity of information,
The application now.
paucity of information pertaining this matter.
Yes.
It has intentionally concealed material facts with the purpose of maliciously detaining the respondent. And Your Honor, in whole, it has no merit on the following basis. Your Honor, Article 149
Counsel, we need intentionally conceal material facts with the intention of.
concealing evidence that
Yes.
should form the basis for the immediate release of the respondent. Your Honor, we oppose this application on the following grounds. Your Honor, the application is anchored on Article 49(1) F and G of the Constitution that guarantees the right of an arrested person to bail. Your Honor, if you read the wording of Article 149(1)G, it talks about the right of an arrested person to bail and bond unless there are compelling circumstances why she should be denied that right. The application and the affidavit before you, Your Honor, has no such. I think we've lost the court.
Yes.
Your Honor, you can hear me?
Yes, Counsel, I can hear you. Proceed.
Your Honor, the application before you has not disclosed any compelling reason why the respondent is actually in custody as we speak.
Yes.
Your Honor, since his arrest, he has fully cooperated with the DCI homicide investigators After his arrest and subsequently the next day, they went to his house in Kitengela. They did a search of the house, I must say without a warrant from the court. A whole day search, trying to find any evidence of any wrongdoing inside the house. And Your Honor, none was found. They also detained Haka, which is currently at Kilimani Police Station. They do not disclose in this affidavit and explain, Your Honor, application that they've also done a thorough search of the car. They even went, Your Honor, to the mall where the deceased car had been parked. And they searched the car, did whatever they were to do there. So they have that information within their knowledge. The same has not been disclosed in this affidavit. Your Honor, since the arrest of the respondent, the applicants, the DCI, have referred to her as a person of interest. Your Honor, a person of interest is not necessarily a suspect. She has not even become a suspect. Is a person essentially who can shed light to the investigations at hand, light which she has already shared with full cooperation. She has written a statement. Your Honor, as we speak, she's not even a suspect before this court. Yet she's already been detained for 3 days, and they want 14 more days to detain an innocent lady whose only mistake is the doctor dying when she was being transported to Nairobi Hospital after she raised an alarm upon his collapse in her house. Your Honor, this affidavit is full of innuendos, alarmism, and sensationalism. Your Honor, if you go to paragraph, Your Honor, if you go to paragraph, let me refer. Now, if you go to paragraph 9 of the affidavit sworn by Sergeant Rhoda Nzioka, she talks about the respondent preparing a meal for the deceased, requested him to rest in the master bedroom, and he talks about intimacy between the deceased and the respondent. Your Honor, intimacy is not a criminal offense. The respondent already disclosed it in the statement that he wrote at the DCI that indeed they were intimate. They were very close friends. And paragraph 9 should not be interpreted in any way as a reason for further detention of the respondent. Your Honor, as the saying goes, you cannot blame the bee for the sweetness of the honey. No offense was committed. You know, you cannot blame the bee for the sweetness of the honey. With full disclosure, there is no error and there is no mistake worthy further detention on the basis of intimacy between the deceased doctor and the respondent. Sorry, Your Honor, come again. Your Honor, we can hardly hear you.
You said with full disclosure there is no.
Your Honor, there is no wrongdoing and no insidious act can be inferred from the fact that the deceased visited the home of the respondent and they subsequently became intimate. It was not the first time. They were close relations. The families knew about it, and therefore it was in the order of business upon such visitation. Your Honor, making further reference to the affidavit before you, the DCI are again insinuating suspected poisoning at the residence of the respondent.
Yes.
They were there for a whole day. They collected all the samples they were supposed to collect. This affidavit shows no basis for that averment. And if there were any basis at all, then the investigation pertaining it has already been conducted. There is no cause to detain the respondent on an innuendo that ought to have already been investigated. Your Honor, the affidavit names other parties who are also helpful in this investigation. It actually talks about a paramedic called Toila Chepkorui on paragraph 9. It talks about a neighbor called Shadrach Korir at paragraph 7. All these people were duly mentioned by the respondent, and the investigation had a chance to ask them to write statements, which they wrote, just like the respondent wrote. They were not arrested, so justifiably because they are not suspects. And Your Honor, from the inference of the word person of interest, not a suspect, we can only draw a reasonable conclusion that the respondent is also a witness to this matter, just like the other parties that have been mentioned, who have been cooperative enough to give all information to the police and condense it in the form of a statement. Your Honor, as I've said, the home permanent residence of the respondent is known in Kitengela. The DCI have been there. Upon securing her liberty, the DCI are at liberty to visit her home anytime. It's an ongoing investigation. If they so wish to treat it as such, they can visit the home of the respondent anytime. If they want a further statement, if they want a clarification, if they want to pick any other document they have not picked. So this is a permanent place of residence where the respondent can be sought and actually found. Therefore, Your Honor, the respondent is not a flight risk. Jurisprudence is clear that the sole major consideration on denial for denial of cash bail and bond, which we are seeking hereby, if the court does not find it fit to release on a personal bond, Your Honor, that consideration is being a flight risk. The respondent is not a flight risk. He has cooperated fully. If she actually, when the paramedics loaded the doctor, who was then alive, and rushed across the expressway towards Nairobi Hospital from Kitengela, that's around 30 kilometers, she quickly got into her car. There were no cops on the vicinity, and followed his good friend, who was in distress, up to the Nairobi hospital. Your Honor, if the respondent was a flight risk, she could have flew at that point, or she could have tried to conceal evidence by locking her house or otherwise. She's been fully cooperative. May that be taken in consideration when the terms for the release of the respondent is determined. Your Honor, as I almost finalize, courts have pronounced themselves consistently. It's settled jurisprudence on this issue. That one, Your Honor, there is jurisprudence at the High Court level that pretrial detention is actually unconstitutional. Your Honor, I'm referring to Michael Rotich versus the Republic. This is a 2016 case, miscellaneous application 304 of 2016. It's found at the EKLR. Your Honor, your brother, Justice Kimaru, application 304 of 2016, that's Nairobi at Milimani, available at the EKLR, where your brother, Justice Kimaru, emphatically held that the DCI, before conducting an arrest, ought to have done investigations already. I mean, they have the prerogative, Your Honor. They could have just ordered the respondent, go and sleep in a friend's house. Let us ransack your house. She had already written a statement. So, Your Honor, the case is clear that it is the responsibility of the DCI to conduct investigations first before they can consider detaining a suspect. In this case, as I've demonstrated, Your Honor, she was detained before investigations. What is that, Your Honor? She was detained before investigations. That is a gross violation of the sanctity of liberty as espoused in multiple articles in the Constitution. And that's why up to now, they are detaining a person of interest. Now, the grossness of that act, in my view, should be subject to another court proceeding on violation of human rights. It is very gross that you can be detained without any investigation being done. And worse, after violation of liberties for 3 days, they appear before you with a flawed, legally flawed affidavit with no material information and seek a further detention for 14 days of a person who has not even been labeled as a suspect.